Hi guys, the CCPA was enacted originally with a focus on many of the practices that are associated with the advertising technology ecosystem, including creating profiles of consumers that include certain personal characteristics. The original version of the CCPA contained legislative findings that support this point. During the CCPA amendments process, there was a particular opposition by consumer advocates to Senate Bill 753, which would have excluded from the definition of sale the process of a publisher making a third-party tag or cookie available on its website or mobile app. The legislative battle around SB 753 culminated with State Senator Henry Stern withdrawing the bill just before it was scheduled to be heard on April 23, 2019. The opposition believes that only contextual advertising could be exempted from the definition of sale for purposes of the CCPA. Contextual advertising is advertising on a website that is targeted to be relevant to the page's content. As the process moves forward, the key issues for the ad tech ecosystem will be first, whether the data sharing will be considered a sale such that it gives rise to consumer right number 4 to opt out of the sale of personal information for adults, or consumer right number 5 to opt in for children under the age of 16. And second, whether liability for CCPA violations can be shifted to an ad tech vendor from the business using the ad tech vendor. While it is debatable whether ad tech should be considered a sale under the CCPA, businesses should understand that consumer groups believe that the placement of cookies on websites fits within the definition of sale. Ostensibly, consumer advocates are relying on the definition of sale that includes making personal information available for valuable consideration per California Civil Code Section 1798140T. There are two exemptions from the definition of sale in the CCPA that hinge upon whether an ad tech vendor is considered a third party or a service provider. A consumer uses or directs the business to intentionally disclose personal information or uses the business to intentionally interact with a third party, provided the third party does not also sell the personal information, unless that disclosure would be consistent with the provisions of this title. An intentional interaction occurs when the consumer intends to interact with a third party via one or more deliberate interactions. Hovering over, muting, pausing, or closing a given piece of content does not constitute a consumer's intent to interact with a third party. And second, the business uses or shares with a service provider personal information of a consumer that is necessary to perform a business purpose if both of the following conditions are met. First, the business has provided notice that information is being used or shared in its terms and conditions consistent with Section 1798135, and second, the service provider does not further collect, sell, or use the personal information of the consumer except as necessary to perform the business purpose. If a business does not want sharing of data to be considered a sale, it should first determine whether the entity they are sharing with could be considered a third party under Section 1798140W or a service provider under Section 1798140V. If the entity is a third party, consider including language on the website or mobile app from which you can obtain international direction from the consumer to share data with the third party in accordance with the exemption to the definition of sale under Section 1798140T2A. If the entity is a service provider, determine whether the appropriate notice has been provided of sharing and consider amending your contracts to include representations and warranties that the service provider does not further collect, sell, or use the personal information of the consumer except as necessary to perform the business purpose, sufficient to comply with Section 1798140T2C. The CCPA does not provide a method for shifting liability to a third party. Of course, a contract can always include indemnity provisions with third parties. The CCPA does envision shifting of liability to service providers under California Civil Section Code 1798145H. The CCPA also envisions shifting liability to persons as defined in the statute that sign a contract which includes the 4 elements as set forth in the discussion under Independent Business Obligation number 3.